The International Court of Justice is the primary judicial branch of the United Nations. It is based in the Peace Palace in The Hague, Netherlands. Its main functions are to settle legal disputes submitted to it by states and to provide advisory opinions on legal questions submitted to it by duly authorized international branches, agencies, and the UN General Assembly. Activities. Established in 1945 by the UN Charter, the court began work in 1946 as the successor to the Permanent Court of International Justice. The Statute of the International Court of Justice, similar to that of its predecessor, is the main constitutional document constituting and regulating the court. The court's workload covers a wide range of judicial activity. To date, the ICJ has dealt with relatively few cases. However, since the 1980s there has been a clear increase in willingness to use the court, especially among developing countries. After the court ruled that the U.S.'s cover war against Nicaragua was in violation of international law, the United States withdrew from compulsory jurisdiction in 1986. The United States accepts the court's jurisdiction only on a case-by-case basis. Chapter 14 of the United Nations Charter authorizes the UN Security Council to enforce court rulings. However, such enforcement is subject to the veto power of the 5 permanent members of the Council, which the United States used in the Nicaragua case. Composition. The ICJ is composed of 15 judges elected to 9-year terms by the UN General Assembly and the UN Security Council from a list of persons nominated by the national groups in the Permanent Court of Arbitration. The election process is set out in Articles 4-19 of the ICJ Statute. Elections are staggered with 5 judges elected every 3 years, in order to ensure continuity within the court. Should a judge die in office, the practice has generally been to elect a judge in a special election to complete the term. No two may be nationals of the same country. According to Article 9, the membership of the court is supposed to represent the main forms of civilization and of the principal legal systems of the world. Essentially, this has meant common law, civil law and socialist law. There is an informal understanding that the seats of the court will be distributed so that there are 5 seats for Western countries, 3 for African states, 2 for Eastern European states, 3 for Asian states and 2 for Latin American and Caribbean states. The 5 permanent members of the United Nations Security Council always have a judge on the court, thereby occupying 3 of the Western seats, 1 of the Asian seats and 1 of the Eastern European seats. The exception was China, which did not have a judge on the court from 1967 to 1985. Because it did not put forward a candidate. Article 6 of the statute provides that all judges should be elected regardless of their nationality among persons of high moral character, who are either qualified for the highest judicial office in their home states or known as lawyers with sufficient competence in international law. Judicial independence is dealt with specifically in Articles 16-18. Judges of the ICJ are not able to hold any other post, nor act as counsel. In practice the members of the court have their own interpretation of these rules. This allows them to be involved in outside arbitration and hold professional posts as long as there is no conflict of interest. A judge can be dismissed only by a unanimous vote of other members of the court. Despite these provisions, the independence of ICJ judges has been questioned. For example, during the Nicaragua case, the USA issued a communique copyright suggesting that it could not present sensitive material to the court because of the presence of judges from Eastern Bloc states. Judges may deliver joint judgments or give their own separate opinions. Decisions and advisory opinions are by majority and, in the event of an equal division, the President's vote becomes decisive. Judges may also deliver separate dissenting opinions. Ad hoc judges. Article 31 of the statute sets out a procedure whereby ad hoc judges sit on contentious cases before the court. This system allows any party to a contentious case who otherwise does not have one of that party's nationals sitting on the court to select one additional person to sit as a judge on that case only. It is possible that as many as 17 judges may sit on one case. This system may seem strange when compared with domestic court processes, but its purpose is to encourage states to submit cases to the court. For example, If a state knows it will have a judicial officer who can participate in deliberation and offer other judges local knowledge and an understanding of the state's perspective, that state may be more willing to submit to the court's jurisdiction. Although this system does not sit well with the judicial nature of the body, it is usually of little practical consequence. Ad hoc judges usually vote in favor of the state that appointed them and thus cancel each other out. Chambers: generally, the court sits as full bench, but in the last 15 years it has on occasion sat as a chamber. Articles 26-29 of the statute allow the court to form smaller chambers, usually 3 or 5 judges, to hear cases. 2 types of chambers are contemplated by Article 26, firstly, chambers for special categories of cases, and second, the formation of ad hoc chambers to hear particular disputes. In 1993 a special chamber was established, under Article 26, 1, of the ICJ statute, to deal specifically with environmental matters. Ad hoc chambers are more frequently convened. For example, chambers were used to hear the Gulf of Maine case. In that case, the parties made clear they would withdraw the case unless the court appointed judges to the chamber who were acceptable to the parties. Judgments of chambers may have less authority than full court judgments, or may diminish the proper interpretation of universal international law informed by a variety of cultural and legal perspectives. On the other hand, the use of chambers might encourage greater recourse to the court and thus enhance international dispute resolution. Current composition: as of April 27, 2012, the composition of the court is as follows: Jurisdiction. As stated in Article 93 of the UN Charter, all 193 UN members are automatically parties to the court statute. Non-UN members may also become parties to the court statute under the Article 93, 2, procedure. For example, before becoming a UN member state, Switzerland used this procedure in 1948 to become a party, and Nauru became a party in 1988. Once a state is a party to the court statute, it is entitled to participate in cases before the court. However, being a party to the statute does not automatically give the court jurisdiction over disputes involving those parties. The issue of jurisdiction is considered in the 2 types of ICJ cases: contentious issues and advisory opinions. Contentious issues. In contentious cases, the ICJ produces a binding ruling between states that agree to submit to the ruling of the court. Only states may be parties in contentious cases. Individuals, corporations, parts of a federal state, NGOs, UN organs and self-determination groups are excluded from direct participation in cases, although the court may receive information from public international organizations. This does not preclude non-state interests from being the subject of proceedings if one state brings the case against another. For example, a state may, in case of diplomatic protection, bring a case on behalf of one of its nationals or corporations. Jurisdiction is often a crucial question for the court in contentious cases. The key principle is that the ICJ has jurisdiction only on the basis of consent. Article 36 outlines 4 bases on which the court's jurisdiction may be founded. First, 36, 1, provides that parties may refer cases to the court. This method is based on explicit consent rather than true compulsory jurisdiction. It is, perhaps, the most effective basis for the court's jurisdiction because the parties concerned have a desire for the dispute to be resolved by the court and are thus more likely to comply with the court's judgment. Second, 36, 1, also gives the court jurisdiction over matters specifically provided for in treaties and conventions in force. Most modern treaties will contain a compromissory clause, providing for dispute resolution by the ICJ. Cases founded on compromissory clauses have not been as effective as cases founded on special agreement, since a state may have no interest in having the matter examined by the court and may refuse to comply with the judgment. For example, during the Iran hostage crisis, Iran refused to participate in a case brought by the U.S. based on a compromissory clause contained in the Vienna Convention on Diplomatic Relations, nor did it comply with the judgment. Since the 1970s, the use of such clauses has declined. Many modern treaties set out their own dispute resolution regime, often based on forms of arbitration. Third, Article 36, 2, allows states to make optional clause declarations accepting the court's jurisdiction. The label compulsory, sometimes placed on Article 36, 2, jurisdiction, is misleading since declarations by states are voluntary. Furthermore, many declarations contain reservations, such as exclusion from jurisdiction certain types of disputes. The principle of reciprocity may further limit jurisdiction. As of February 2011, 66 states had a declaration in force. Of the Permanent Security Council members, only the United Kingdom has a declaration. In the court's early years, most declarations were made by industrialized countries. Since the Nicaragua case, declarations made by developing countries have increased, reflecting a growing confidence in the court since the 1980s. Industrialized countries, however, have sometimes increased exclusions or removed their declarations in recent years. Examples include the United States, as mentioned previously, in Australia, who modified their declaration in 2002 to exclude disputes on maritime boundaries. Finally, 36(5) provides for jurisdiction on the basis of declarations made under the Permanent Court of International Justice's statute. Article 37 of the statute similarly transfers jurisdiction under any compromissory clause in a treaty that gave jurisdiction to the PCIJ. In addition, the court may have jurisdiction on the basis of tacit consent. In the absence of clear jurisdiction under Article 36, jurisdiction will be established if the respondent accepts ICJ jurisdiction explicitly or simply pleads on the merits. The notion arose in the Corfu Channel case, in which the court held that a letter from Albania stating that it submitted to the jurisdiction of the ICJ was sufficient to grant the court jurisdiction. Advisory opinion. An advisory opinion is a function of the court open only to specified United Nations bodies and agencies. On receiving a request, the court decides which states and organizations might provide useful information and gives them an opportunity to present written or oral statements. Advisory opinions were intended as a means by which UN agencies could seek the court's help in deciding complex legal issues that might fall under their respective mandates. In principle, the court's advisory opinions are only consultative in character but are influential and widely respected. Whilst certain instruments or regulations can provide in advance that the advisory opinion shall be specifically binding on particular agencies or states, they are inherently non-binding under the statute of the court. This non-binding character does not mean that advisory opinions are without legal effect, because the legal reasoning embodied in them reflects the court's authoritative views on important issues of international law and, in arriving at them, the court follows essentially the same rules and procedures that govern its binding judgments delivered in contentious cases submitted to it by sovereign states. An advisory opinion derives its status and authority from the fact that it is the official pronouncement of the principal judicial organ of the United Nations. Advisory opinions have often been controversial because the questions asked are controversial or the case was pursued as an indirect way of bringing what is really a contentious case before the court. Examples of advisory opinions can be found in the section Advisory Opinions in the list of International Court of Justice cases article. One such well-known advisory opinion is the nuclear weapons case. ICJ and the Security Council, Article 94, establishes the duty of all UN members to comply with decisions of the court involving them. If parties do not comply, the issue may be taken before the Security Council for enforcement action. There are obvious problems with such a method of enforcement. If the judgment is against one of the permanent 5 members of the Security Council or its allies, any resolution on enforcement would then be vetoed. This occurred, for example, after the Nicaragua case, when Nicaragua brought the issue of the U.S.'s non-compliance with the court's decision before the Security Council. Furthermore, if the Security Council refuses to enforce a judgment against any other state, there is no method of forcing the state to comply. Furthermore, the most effective form to take action for the Security Council, coercive action under Chapter 7 of the United Nations Charter, can be justified only if international peace and security are at stake. the Security Council has never done this so far. The relationship between the ICJ and the Security Council, and the separation of their powers, was considered by the Court in 1992 in the Pan Am case. The Court had to consider an application from Libya for the order of provisional measures to protect its rights, which, it alleged, were being infringed by the threat of economic sanctions by the United Kingdom and United States. The problem was that these sanctions had been authorized by the Security Council, which resulted in a potential conflict between the Chapter 7 functions of the Security Council and the judicial function of the Court. The Court decided, by 11 votes to 5, that it could not order the requested provisional measures because the rights claimed by Libya, even if legitimate under the Montreal Convention, prima facie could not be regarded as appropriate since the action was ordered by the Security Council. In accordance with Article 103 of the UN Charter, obligations under the Charter took precedence over other treaty obligations. Nevertheless, the Court declared the application admissible in 1998. A decision on the merits has not been given since the parties settled the case out of court in 2003. There was a marked reluctance on the part of a majority of the Court to become involved in a dispute in such a way as to bring it potentially into conflict with the Council. The Court stated in the Nicaragua case that there is no necessary inconsistency between action by the Security Council and adjudication by the ICJ. However, where there is room for conflict, the balance appears to be in favor of the Security Council. Should either party fail to perform the obligations incumbent upon it under a judgment rendered by the Court, the Security Council may be called upon to make recommendations or decide upon measures if the Security Council deems such actions necessary. In practice, the Court's powers have been limited by the unwillingness of the losing party to abide by the Court's ruling, and by the Security Council's unwillingness to impose consequences. However, in theory, so far as the parties to the case are concerned, a judgment of the Court is binding, final and without appeal, and by signing the Charter, a state member of the United Nations undertakes to comply with any decision of the International Court of Justice in a case to which it is a party. For example, the United States had previously accepted the Court's compulsory jurisdiction upon its creation in 1946, but in Nicaragua v. United States withdrew its acceptance following the Court's judgment in 1984 that called on the U.S. to cease and to refrain from the unlawful use of force against the government of Nicaragua. The Court ruled that the United States was in breach of its obligation under the Treaty of Friendship with Nicaragua not to use force against Nicaragua, and ordered the United States to pay war reparations. Examples of contentious cases: a complaint by the United States in 1980 that Iran was detaining American diplomats in Tehran in violation of international law. A dispute between Tunisia and Libya over the delimitation of the continental shelf between them. A dispute over the course of the maritime boundary dividing the U.S. and Canada in the Gulf of Maine area. A complaint by the Federal Republic of Yugoslavia against the member states of the North Atlantic Treaty Organization regarding their actions in the Kosovo War. This was denied on December 15, 2004 due to lack of jurisdiction, because the FRY was not a party to the ICJ statute at the time it made the application. A complaint by the Republic of Macedonia that Greece is, by vetoing their accession to NATO, in violation of the Interim Accord of September 13, 1995 between the two countries, was decided in favor of Macedonia on December 5, 2011. Law applied. When deciding cases, the Court applies international law as summarized in Article 38 of the ICJ statute, which provides that in arriving at its decisions the Court shall apply international conventions, international custom, and the general principles of law recognized by civilized nations. It may also refer to academic writing and previous judicial decisions to help interpret the law, although the Court is not formally bound by its previous decisions under the doctrine of stare decisis. Article 59 makes clear that the common law notion of precedent or stare decisis does not apply to the decisions of the ICJ. The Court's decision binds only the parties to that particular controversy. Under 38(1)(d), however, the Court may consider its own previous decisions. If the parties agree, they may also grant the Court the liberty to decide ex aequo bono, granting the ICJ the freedom to make an equitable decision based on what is fair under the circumstances. This provision has not been used in the court's history. So far, the International Court of Justice has dealt with about 130 cases. Procedure: the ICJ is vested with the power to make its own rules. Court procedure is set out in Rules of Court of the International Court of Justice 1978. Cases before the ICJ will follow a standard pattern. The case is lodged by the applicant, who files a written memorial setting out the basis of the court's jurisdiction and the merits of its claim. The respondent may accept the court's jurisdiction and file its own memorial on the merits of the case. Preliminary objections: a respondent who does not wish to submit to the jurisdiction of the court may raise preliminary objections. Any such objections must be ruled upon before the court can address the merits of the applicant's claim. Often a separate public hearing is held on the preliminary objections and the court will render a judgment. Respondents normally file preliminary objections to the jurisdiction of the court and/or the admissibility of the case. Inadmissibility refers to a range of arguments about factors the court should take into account in deciding jurisdiction. For example, that the issue is not justiciable or that it is not a legal dispute. In addition, objections may be made because all necessary parties are not before the court. If the case necessarily requires the court to rule on the rights and obligations of a state that has not consented to the court's jurisdiction, the court will not proceed to issue a judgment on the merits. If the court decides it has jurisdiction and the case is admissible, the respondent will then be required to file a memorial addressing the merits of the applicant's claim. Once all written arguments are filed, the court will hold a public hearing on the merits. Once a case has been filed, any party may seek an order from the court to protect the status quo pending the hearing of the case. Such orders are known as provisional measures and are analogous to interlocutory injunctions in United States law. Article 41 of the statute allows the court to make such orders. The court must be satisfied to have prima facie jurisdiction to hear the merits of the case before granting provisional measures. Applications to intervene: in cases where a third state's interests are affected, that state may be permitted to intervene in the case, and participate as a full party. Under Article 62, a state with an interest of a legal nature may apply. However, it is within the court's discretion whether or not to allow the intervention. Intervention applications are rare. The first successful application occurred in 1991. Judgment and remedies: once deliberation has taken place, the court will issue a majority opinion. Individual judges may issue separate opinions or dissenting opinions. No appeal is possible, though any party may ask for the court to clarify if there is a dispute as to the meaning or scope of the court's judgment. Criticisms: the International Court has been criticized with respect to its rulings, its procedures, and its authority. As with United Nations criticisms as a whole, many of these criticisms refer more to the general authority assigned to the body by member states through its charter than to specific problems with the composition of judges or their rulings. Major criticisms include: compulsory jurisdiction is limited to cases where both parties have agreed to submit to its decision, and, as such, instances of aggression tend to be automatically escalated to and adjudicated by the Security Council. According to the sovereignty principle of international law, no nation is superior nor inferior against another. Therefore, there is no entity that could force the states into practice of the law or punish the states in case any violation of international law occurs. Therefore, due to the absence of binding force, although there are 193 member states of the ICJ, the members do not necessarily have to accept the jurisdiction. Moreover, membership in the UN and ICJ does not give the court automatic jurisdiction over the member states, but it is the consent of each state to follow the jurisdiction that matters. Organizations, private enterprises, and individuals cannot have their cases taken to the International Court, such as to appeal a national Supreme Court's ruling. UN agencies likewise cannot bring up a case except in advisory opinions. Only the states can bring the cases and become the defendants of the cases. This also means that the potential victims of crimes against humanity, such as minor ethnic groups or indigenous peoples, may not have appropriate backing by a state. Other existing international thematic courts, such as the ICC, are not under the umbrella of the International Court. Unlike ICJ, international thematic courts like ICC work independently from United Nations. Such dualistic structure between various international courts sometimes makes it hard for the courts to engage in effective and collective jurisdiction. The International Court does not enjoy a full separation of powers, with permanent members of the Security Council being able to veto enforcement of cases, even to which they consented to be bound. Because the jurisdiction does not have binding force itself, in many cases the instances of aggression are adjudicated by Security Council by adopting a resolution, etc. There is, therefore, a likelihood for the permanent member states of Security Council to avoid the responsibility brought up by International Court of Justice, as shown in the example of Nicaragua v. United States. See also: International Criminal Tribunal for Rwanda, International Criminal Tribunal for the former Yugoslavia, List of International Court of Justice cases, List of treaties that conferred jurisdiction on the International Court of Justice, Mondialization, Peremptory Norm, United Nations Economic and Social Council, United Nations Secretariat, United Nations Trusteeship Council, Universal Jurisdiction, World Citizen, Notes. Further reading, Dunn, Michael. Isolationism of a Kind, Two Generations of World Court Historiography in the United States, Journal of American Studies 21 No. 3 pages 327–351. Rosenes, Rosenes The World Court, What It Is and How It Works 6th ed. Decisions of the World Court relevant to the UNCLOS and contents and indexes dedicated to former ICJ President Stephen M. Schabel, Van der Wolf W. and Dorota D., the International Court of Justice, Facts and Documents about the History and Work of the Court, External Links, International Court of Justice, Official Site, 2, ICJ Multimedia Gallery, List of cases ruled upon by the ICJ since its creation in 1946, the Statute of the International Court of Justice on the United Nations AVL, Summary of the Procedural History, List of selected preparatory documents and audio-visual material related to the negotiations and adoption of the statute. Hague Justice Portal, Academic Gateway to the Hague Organizations concerning international peace, justice and security. International Criminal Court. See also, a tribunal to prosecute individuals for genocide, crimes against humanity, war crimes, and the crime of aggression. Lectures, The ICJ in the Service of Peace and Justice, conference organized on the occasion of the centenary of the Peace Palace, lecture by Orn Shaukat El-Kajani entitled Reflections on the Jurisdiction of the International Court of Justice in the lecture series of the United Nations Audiovisual Library of International Law, lecture by Mohamed Ben Anna entitled La Cour internationale de justice, juge des souverainetés copyright S. In the lecture series of the United Nations Audiovisual Library of International Law, lecture by Philippe Cavra entitled La Cour internationale de justice in the lecture series of the United Nations Audiovisual Library of International Law, lecture by Vera Jolan Debers entitled The International Court of Justice as the Principal Judicial Organ of the United Nations in the lecture series of the United Nations Audiovisual Library of International Law, lecture by Mariko Corno entitled Some Salient Features of the Contemporary International Disputes in the Precedents of the International Court of Justice in the lecture series of the United Nations Audiovisual Library of International Law, lecture by Mariko Corno entitled International Court of Justice and Disputes Involving the Interests of Third Parties to the Proceedings or the Common Interests of the International Community as a Whole or of the Community established by a Convention in the lecture series of the United Nations Audiovisual Library of International Law, lecture by Edward McWhinney entitled Judicial Activism and the International Court of Justice in the lecture series of the United Nations Audiovisual Library of International Law, lecture by Alain Pellet entitled Concealed Devant La Cour internationale de justice in the lecture series of the United Nations Audiovisual Library of International Law, lecture by Iwi Longshi entitled The Present and Future Role of the International Court of Justice in the Peaceful Settlement of International Disputes in the lecture series of the United Nations Audiovisual Library of International Law.